In today's session, we will study about the types of majorities in Parliament, the amending procedure of the Constitution of India, and the basic structure doctrine. Okay, so types of majorities पढ़ला पूर्वरु आमे first amendment of constitution देखिबा amendment constitution रे ही तमरो constitution केमिति amendment करा जिवो तार procedure रे ही हमरो को majority अछि सेगुडा हमें देखिदबा तो amendment of constitution that is under part 20 under article 368 okay part 20 रे गोटे article अछि that is article 368 that deals with the amendment of the constitution तो evolution of constitutional amendment doctrine in India तो एई case laws मानकर evolution एटा को carefully देखिथियो because this similar case law will study in basic structure doctrine also okay so in the beginning of the session we will study about the case laws and in the ending also we will again revise the same so first start होची शंकरी प्रसाद case in 1951 so शंकरी प्रसाद case रे first amendment of the constitution that is first constitutional amendment 1951 जोटा कराइदरा सेठी challenge कराइथला शंकरी प्रसाद case रे so first constitutional amendment रे it was dealing with the curtailing of right to property that was challenged okay so that was challenged so Supreme Court ruled that the term law in article 13 excludes constitutional amendments तो parliament चाहिए parliament चाहिए amendment कर परिबो and these amendments are not subject to the term law in article 13 so article 13 deals with judicial review yeah just a second article 13 deals with judicial review and article 13 ro clause 3 deals with law okay so article 13 clause 3 deals with law and Supreme Court said that this word under article 13 this word law includes only ordinary laws and not the constitution amendment laws okay so uh, parliament can change the constitution which will not be subject to judicial review then एथरे देखा लिखा है बट देन सज्जन सिंह केस गोटे आसला 1964 रे ओके 1964 रे तमरो सज्जन सिंह केस आसला सज्जन सिंह केस रे सेम दिन आश्वासन कराइतला जे दिस टर्म लॉ अंडर आर्टिकल 13 डज नॉट इंक्लूड द कॉन्स्टिट्यूशन अमेंडमेंट लॉज देन कम्स द गोलोकनाथ केस इन 1967 court reversed its stance that the term law under article 13 includes constitutional amendments and parliament cannot abridge the fundamental rights okay now ebe supreme court कहला जे law word under article 13 clause 3 includes the constitutional amendment laws also and the rights that is the fundamental rights are transcendental and immutable तो fundamental rights संगरे parliament किछि modification कर परिबोनी then parliament reacted with the 24th constitutional amendment act of 1971 that is the parliament कौन कला article 13 को amend कर देला and article 13 clause 3 रे article 13 clause 3 रे गोटे provision add कला जे the constitutional amendment laws are not subjected to the term law in article 13 okay so parliament amended article 13 and also article 368 to counter the Goloknath judgment and parliament said that parliament can take away any fundamental right and under article 368 and such act will not be considered as a law under article 13 clause 3 this is the 24th constitution amendment act then comes the Kesavananda Bharati case in 1973 Supreme Court upheld the 24th amendment but introduced the basic structure doctrine okay Supreme Court कहला जे हाँ ठीक अछि parliament चाहिए सब किसी amend कर परियो but basic structure संगरे से modification किसी कर परिबोनी okay तो केशवानंद भारती केस very important case तमरा 24th April 1973 please remember this date this is a very important thing एटा maybe को एग्जाम रे पचार भी दे पारंती 24th April 1973 constitution जो केशवानंद भारती केस रो जजमेंट आस्तला where doctrine of basic structure was introduced for the first time so ए जो केस ता गोटे फैक्ट मन रखियो केशवानंद भारती केस एथिरे 13 judge constitutional bench 13 judge constitutional bench they sat and decided this Kesavananda Bharati case and till today this bench is the largest ever constitutional bench that has been made by the Supreme Court Then comes the 42nd Constitutional Amendment Act of 1976, the mini constitution. Parliament reacts to the basic structure doctrine with sweeping changes. Okay, so 42nd Amendment Act se jemti kardala je there is no limitation on amending power of Parliament, and fundamental rights can also be amended by the Parliament, and एमिति किसी amendment हेले एटाकू कोर्ट क्वेश्चन करि परिबो नाही. Okay, so এটা ଥିଲା ତମର 42nd Amendment Act. Then comes the Minerva Mills case. Supreme Court invalidated the 42nd Amendment provisions and reaffirmed that judicial review is the basic structure of constitution, and Parliament ର ଯାହା ବି amendment କରିବ that can be subjected to judicial review in Minerva Mills case 1980. Then 1981 ରେ ବି Waman Rao case ରେ court again affirmed the basic structure doctrine and said that the basic structure doctrine applies to post Kesavananda Bharati judgment, that is after 24th April 1973. So this is the evolution of constitutional amendment doctrine in India. Okay, so constitutional amendment केमती करा जाए? So process is so this constitutional amendment process, it makes changes to the supreme law of India, that is the constitution. This provision has been borrowed from the South African constitution. So it is neither completely flexible, not completely rigid. Flexible in the UK re, it is flexible. US re, the amendment procedure is rigid. So India re, it has synthesis of both flexibility and rigidity. Parliament can amend most provisions, but not the basic structure. Okay. Amendments to Article 368. Okay. Amendments to Article 360. Okay, Article 368 deals with the amendment procedure of Constitution. The 368 रे 24th Constitution Amendment 1971 रे amendment ହେଇଥିଲା जे Parliament रो power clarify कराइଥିଲା जे कहैଥିଲା जे 24th CAA 1971 रे कहैଥିଲା जे President is bound to give assent to the constitutional amendment bills. Okay, President is bound to give assent even though there is no the President may not be consulted while introducing a constitutional amendment bill into the Parliament. President may not be consulted, but in the end, जदि तार procedure pass करिगला, President has to give assent. Okay, President has to give assent. एटा 24th CAA रे introduce कराइतला. 42nd Constitution Amendment Act रे तमरा further expanded Parliament's amending power, as we have already seen that Parliament can amend anything, and these amendments cannot be questioned by the court. Okay, एबे procedure केमतिया Article 368 रे first introduction, it can be introduced in either house of Parliament, both Lok Sabha and Rajya Sabha, by any member, a minister or private member, include any MP can introduce this bill. But please note that state legislature cannot introduce a constitutional amendment bill except Article 169. Okay, Article 169 टा कौन कहिछि that states can ask the Parliament for creation or abolition of legislative councils. Okay, states can ask the Parliament for creation or abolition of legislative councils. Okay, so ଏଇ ଜିନିଷ ଏଇ ଆର୍ଟିକଲ ରେ ହିଁ କେବଳ ଷ୍ଟେଟ ମାନଙ୍କର ଗୋଟେ ଇନଡାଇରେକ୍ଟ ଇନଭଲଭମେଣ୍ଟ ରହୁଛି, ଡାଇରେକ୍ଟ ବି ନାହିଁ, ଇନଡାଇରେକ୍ଟ ଇନଭଲଭମେଣ୍ଟ, ସେମାନେ ଖାଲି ସଜେଷ୍ଟ କରିପାରିବେ. ଓକେ, କେବଳ ଏଇ କେସ ରେ ହିଁ ଇନଡାଇରେକ୍ଟଲି states can introduce a constitution amendment bill, otherwise states have no power to introduce constitution amendment bills. Okay, president ro role before introduction. Okay, no prior permission is needed. I already कहली. Majority needed is okay, Article 368 रे तमरो majority कौन दरकार दीटा डिफाइन कराइछि सेटा हमें जस्ट एबे देखिबा. ओके, व्हाट इज द मेजॉरिटी नीडेड? स्पेशल मेजॉरिटी, दैट इज 50% of total membership of each house plus 2/3 of members present and voting of each house. This is one type of special majority specified under Article 368. Okay, so this special majority must be passed separately. Please note, separately by both houses. No joint sitting if deadlock. Okay, जदि deadlock ହେଇगला joint sitting हबो नाही. And second procedure of second type of majority, that is given in Article 368. Okay, 368 रे ही दिया छि. गोटे होची स्पेशल मेजॉरिटी हम जेमति देखिलु 50% of total house membership plus 2/3 of member present and voting plus ratification by at least half of the state legislatures by simple majority. Okay, this ratification is needed for amending the federal features of the constitution where the interest of states are involved. Okay, so এই মেথডটা তোমরা 368 রে হি স্পেসিফাই করা হইছি. So president's assent. Okay, এটা আমি দেখিলা 24th CA রে parliament can amend any provision, president is bound to give assent. Okay, president cannot withhold or return the bill. Okay, so president has to give assent. After assent, bill becomes an act, constitution is amended. Okay. Now comes the types of majorities. Okay, types of majorities. तमरो जितक देखा है फर्स्ट हम जीवा टेबल टा देखिदवा. ओके, टाइप्स ऑफ मेजोरिटीज. तो देखो तुमरो सातटा टाइप ऑफ मेजोरिटी अच्छी. तो तुमरो फर्स्ट तीनटा टाइप ऑफ मेजोरिटी तुमरो 50% वाला मेजोरिटी. ओके, लिखि दउची 50% वाला मेजोरिटी. आउ बाकी चारटा मेजोरिटी तुमरो 66% वाला मेजोरिटी. ओके, 66% वाला मेजोरिटी. ओके, तो देखो जेमती तुमरो इट इज 50%, 50%, 50% ये तीनटा प्रोविजन. बाकी सब थरे तुमरो टू थर्ड के टू थर्ड then two third. Okay, एवढे सब 66% वाला. Okay, so there are 7 types of majorities. First is simple majority. Simple majority means more than 50% of members present and voting. Only 50% of members जदि जो माने present and voting अछंती and जदि just quorum को follow करथुए. The quorum is 1/10 of total house membership. 1/10 of total house membership जदि follow करथुए आ जदि 50% of members present and voting करदेले ताहले तमरो बिल टा पास हेजिवो. That through simple majority. Okay, जदि quorum fulfill करा हेची, quorum is specified under article 100 clause 3. Okay, जदि quorum को specify को satisfy करा हला then only 50% of members present and voting रे तमरो simple majority pass हेजिवो. Okay, vacant seats की absentees these are not counted. Okay, so this type of bills are not counted under article 368. Okay, so Supreme Court okay, the ଜିନିଷ ଦେଖିଦବ not counted under article 368. article 368 ରେ ମୁଁ ଯେମିତି କହିଲି ତମର ଦିଟା majority जो ଅଛି ସେଟା ଆମେ ଏବେ ବି ଦେଖିବା ଆଉ ଥରେ. ତମର ଏଇ जो article 368 ରେ ତମର ଏଇ जो ଦିଟା majority ଅଛି नंबर 5th ଆଉ 6th नंबर, ଏଇ ଦିଟା majority को ही तमरो constitutional amendment act रे गणा जाए. Okay, बाकी जहाँ भी सब constitutional amendment होगा that is not counted as constitutional amendment acts. Okay, only the provisions that fulfill the condition under specified under article 368 they qualify to be called as constitutional amendment act. Please note this point. Okay, so simple majority, these either जहाँ भी bill pass these are not covered under article 368. Example, Supreme Court number of judges increase करागला in 2019, increase from 31 to 34 through ordinary voting. Okay, through ordinary bills, motions, resolutions, adjournment. Okay, तो एटा simple majority रे भी तमरो चेंज करी है पारला. Okay, absolute माने 50% of total house membership. Okay, irrespective of vacancies or absentees. Okay, 50% of total membership not present and voting. So required for government to prove majority support in Lok Sabha जेमती confidence की no confidence motion होला सेठी तमरा absolute majority दरकार. Effective majority, that is more than 50% of effective strength. What is effective strength? Total strength minus vacancies. Okay, तो सेही टाइम रे सेही पार्लियामेंट रे केते जण अछंती, that is the effective strength. Effective majority कोन 50% of effective strength. 50% of effective strength. Okay, तो कोटि कोटि एटा यूज हुए रिमूवल ऑफ प्रिजाइडिंग ऑफिसर्स, that is the speaker and deputy speaker of Lok Sabha and chairman or deputy chairman of Rajya Sabha. Now comes the 66% वाला amendment. 66% वाला majority जो होगा, that is under article 249, at least 2/3 of members present and voting. Okay, at least 2/3 of member present and voting. Okay, present and voting, not key total membership, present and voting only. That is under article 249. जेमती Rajya Sabha is empowered by parliament to legislate on state subjects if it is subject to national interest. तो ये article ले तमरो special majority demand करे, that is 2/3 of members present and voting. This majority is specified under article 249. Please note. Next comes the 368, dual requirement, 50% of total membership of each house plus 2/3 of member present and voting. Constitutional amendments that do not change the federal structure. Okay, it is specified under article 368. Then another majority, special majority specified under article 61, that deals with the impeachment of president. कौन दरकार सेतरे total of 2/3 of total membership of house. Only total membership of house, not present and voting. 2/3 of total membership. Okay. Next, special majority. This is also specified under article 368. That is special majority of parliament, 50% of membership of each house plus 2/3 of members present and voting, plus ratification by greater than 50% of state legislatures by simple majority. Okay, state legislature जो माने pass करिवे by simple majority, parliament रे special majority दरकार plus ratification by half of the state legislatures. Okay, तो एटा 368 रे मेंशन करा हेची ओके एथिरे तमरो टाइम लिमिट किसी दिया हैनी स्टेट लेजिस्लेचर मान को एक्ट करिया पे किसी टाइम लिमिट नाही आउ स्टेट लेजिस्लेचर माने जदी किसी एक्शन पे न नेले तो जदी केवल बाकी 50% स्टेट माने एक्सेप्ट कर देले देन सेही स्टेट रो कंसेंट किसी किसी मैटर करेन ओके so federal provision amendment example in the GST act okay so these are the types of majorities तमरो एई मेजोरिटी गोटा तमरो कन्वेंशन रे करा जाए ओके बाकी तमरो एई जो इफेक्टिव स्ट्रेंथ हो एगुडा तमरो पार्लियामेंट रे एटा तमरो एटा तमरो सिंपल मेजोरिटी एब्सोल्यूट मेजोरिटी एगुडा को जगह रे सब जगह रे कॉन्स्टिट्यूशन रे मेंशन भी हेइछ जे कॉन्स्टिट्यूशन रो को प्रोविजन गुडा को तमे सिंपल मेजोरिटी अमेंड कर परिबो इफेक्टिव मेजोरिटी अमेंड कर परिबो ओके की स्पेशल मेजोरिटी दिस टाइप्स ओके तो सेम थिंग तमरा टेबुल रे भी दिया है तमरा ए जो 50% वाला मेजोरिटीज और 66% वाला मेजोरिटीज तमे देखिले हमें जेमती तमरा एपर तीनटा अछंती एतरे चारिटा टाइप अछंती टोटल 7 टाइप्स ओके तो टेक्स्ट देखिदवा सेम जिनस लिखा है आउ रिवाइज करदवा सिंपल मेजोरिटी मेजोरिटी ऑफ मेंबर्स प्रेजेंट एंड वोटिंग नॉट कंसीडर्ड अंडर आर्टिकल 368 ओके आई हैव टोल्ड यू आर्टिकल 368 रा प्रोसेस रे जो दीटा मेजोरिटी स्पेसिफाई कराई जो कॉन्स्टिट्यूशन अमेंडमेंट बिल से दीटा प्रोसीजर थ्रू जाईची ओनली दोज बिल्स आर काउंटेड एज कॉन्स्टिट्यूशन अमेंडमेंट्स ओके बाकी बाकी जेमती सिंपल मेजोरिटी रे हां कॉन्स्टिट्यूशन अमेंडमेंट हेई परिबो बट दोज आर नॉट कंसीडर्ड एज कॉन्स्टिट्यूशन अमेंडमेंट एक्ट ओके जेमती तमरा 100 फर्स्ट 100 सेकंड कॉन्स्टिट्यूशन अमेंडमेंट एक्ट सेमिति थमड़ा कंसीडर करा जीवनी ओके सिंपल मेजोरिटी रे फॉर एग्जांपल सुप्रीम कोर्ट मानक जज इंक्रीज कराला फ्रॉम 31 टू 34 ओके थ्रू 2019 एक्ट रे एब्सोल्यूट मेजोरिटी रे definition is majority 50% of total membership of house regardless of vacancies and absentees effective majority majority of effective strength that is total strength minus vacancies that is removal of house chair okay chairman rajya sabha chairman ki lok sabha speaker okay special majority under article 249 as I have said by definition not less than two-thirds of members present and voting जो तमरा राज्य सभा जेतबेले पार्लियामेंट को स्टेट मान पई लेजिस्लेचर तयारी करियो रिक्वेस्ट करिवो दैट इज 249 स्पेशल मेजोरिटी अंडर आर्टिकल 368 okay majority of total membership irrespective of vacancies and majority of total membership okay irrespective of vacancies and absentees and not less than two-thirds of members present and voting for example the 103rd amendment then impeachment of president, not less than two-thirds of total membership of House, special majority plus consent of states dealing with federal provisions of the Constitution. If states do not act, it does not matter. Once the 50% criteria is reached, it is done. No time limit for states to ratify the bill. Okay. Example, the GST Act. And तापर किछि एग्जांपल दिया है को कॉन्स्टिट्यूशन प्रोविजन कोडा स्पेशल मेजॉरिटी रे अमेंड करी हबो जेमति कि एडमिशन ऑफ न्यू स्टेट्स अंडर आर्टिकल 2 फॉर्मेशन एंड अल्टरेशन ऑफ एक्जिस्टिंग स्टेट्स अंडर आर्टिकल 3 सेकंड शेड्यूल द एबोलिशन ऑफ क्रिएशन ऑफ लेजिस्लेटिव काउंसिल्स अंडर आर्टिकल 169 ओके एटा म ऑलरेडी कहिछि तमरो स्टेट्स हैव एन इनडायरेक्ट पावर टू मूव फॉरवर्ड दिस कॉन्स्टिट्यूशन अमेंडमेंट इनडायरेक्ट पावर Quorum of Parliament, Article 100, Clause 3. Salaries and allowances of members, Article 106. Rules of procedure, Article 118. Use of English, number of puissant means junior judges. Okay, junior judges, parliamentary privileges under Article 105. Jurisdiction of Supreme Court under Article 138. Okay, official languages under 343. Citizenship provisions of election and delimitation of constituencies under Article 82. Okay, under Article 82, please note that Article 82 रे कुहा delimitation commission जो कुहा delimitation commission is not a constitutional body. Okay, Article 82 रे तमरा पार्लियामेंट को इंस्ट्रक्शन दिया है पार्लियामेंट कैन मेक ए बॉडी बाय लॉ टू डील विद द डिलिमिटेशन ऑफ कॉन्स्टिट्यूएंसीज पार्लियामेंट गोटे लॉ रे डिलिमिटेशन कमिशन को तयारी करे ओके डिलिमिटेशन कमिशन तमर चार थर तयारी हेची डिलिमिटेशन कमिशन तमे से कहि परियो इट इज अ स्टैट्यूटरी बॉडी नॉट ए कॉन्स्टिट्यूशनल बॉडी ओके एटा में भी क्वेश्चन आसी पारे आउ सॉरी सिंपल मेजॉरिटी रे यूनियन टेरिटरीज 5th शेड्यूल आर्टिकल 244 क्लॉज 1 6th शेड्यूल 244 क्लॉज 2 एगुडा सब अमेंड करी हबो ओके provisions with special majority जोटी की fundamental rights the PSP okay special majority of article 368 जो तरह की state ratification दरकार नहीं fundamental rights DPSP all provisions not covered under the first and third categories okay so सेमती एटा जदि हम 1 2 3 4 okay देछि not covered under first and third categories okay so first and third कंपाई कराई जी special majority first or third. Okay, article 61 or 249, these are not included under article 368. The second and fourth, these are included under article 368. Okay, then provisions with special majority ratification of half of states, presidential election 54 and 55, executive power of union and states, supreme court and high courts 124 and 214. Okay, तो एवढा सब simple ଜିନିଷ, distribution of legislative powers, GST council 7th schedule article 246, please remember this article. Article 246 deals with 7th schedule. Representation of states in parliament, article 368 itself, the amendment of constitution. So these deal with the federal features of the constitution. That's why they also need ratification by half of the states. Okay, criticism: unlike USA, states cannot initiate amendments except the legislative council's resolution, that is under article 169. Okay, तो तमर यूएसए रे गोटे कॉन्स्टिट्यूशन कन्वेंशन थाए. ओके, कॉन्स्टिट्यूशन कन्वेंशन थाए जोटा कि इट इज ए स्पेशल बॉडी टू अमेंड द कॉन्स्टिट्यूशन. ओके, तो एमती किछि बॉडी नाही, हमरो स्पेशल बॉडी नाही constitution amendment by. There is no time limit for states to ratify or reject an amendment. Okay, again, if a state gives approval, there is no provision of withdrawal of state approval once it is given. No special body for amendment. हमें देखिले state consent needed only in few cases. Okay, few cases, that is the federal structure जोटा के amendment करागला से state ର consent दरकार. No provision for joint sitting on amendments. Okay, amendment कोटा actually बहुत गोटे बड़ जिनस हवा कथा, तापे joint sitting में भी provision रखिया कथा, but to maintain, I think, to maintain stability of the constitution, not to change it, to change it frequently, there is no provision of joint sitting. Judicial intervention is possible due to vague provisions. Okay, बहुत जगह रे constitution amendment रे judiciary भी interfere कर पारे if the amendment violates the basic structure of constitution. Okay, now comes the, ଏବେ ତ ଆମେ ଦେଖିଲେ amendment procedure, ଏବେ major constitution amendment acts. Okay, so 51 of 2023 मेजर एटा गोटे डायग्राम दिया है तुमरा इजी रिकॉल पाई. तो आमे देखि दवा कोन कोन हेतला कॉन्स्टिट्यूशन अमेंडमेंट एक्ट रे. फर्स्ट कॉन्स्टिट्यूशन अमेंडमेंट एक्ट ऑफ 1951. सो दिस फर्स्ट कॉन्स्टिट्यूशन अमेंडमेंट एक्ट वाज मेड बाय द प्रोविजनल पार्लियामेंट. ओके, तुम जानछो तुमरा कॉन्स्टिट्यूएंट असेंबली ही फंक्शन टिल द functioned as the provisional parliament till the election of the first government. Okay, तमरो एई provisional parliament ही first constitution amendment act 1951 कला. This provisional amendment had just finished drafting the constitution, and again just 1950 रे constitution accept हला परे first year रे ही तमरो first constitution amendment act आसिला. Okay, so it empowered the states to make special provision for social and economically backward class, that is the एथरे तमरो article 15 clause 4. Okay, 15 clause 4 and 16 रे भी तमरा amendment करा हितला जे state can make special provision for the advancement of social economic backward caste and SC/ST. Okay, so it also shaped laws relating to acquisition of estates. Okay, acquisition of estates में तमरा article 31A introduce करा हला. Added the 9th schedule article. 9th schedule article तमरा 31B. Okay, 31B is the 9th schedule article. It protects land reforms and related laws from judicial review. Okay, 9th schedule रे जो article आसीगला, जो सॉरी जो लॉ आसीगला ताको जुडिशियल रिव्यू करी होबनी. ओके, inserted article uh, inserted article 31 no 31A and 31B. Okay, so this 31 article 31 was repealed by the 44th constitutional amendment act. Okay, repealed by the 44th constitutional amendment act, so it is not important. Article 31 number 31A or 31B. Okay, 31A provides for acquisition of estates, 31B is the 9th schedule. Okay, and added 3 new restrictions to article 19 clause 1. Okay, article 19 तमरो तीनटा restriction add कला in article 19 clause 2. Okay, clause 2 हबा एटा article 19 clause 2 जो थरे की reasonable restrictions provide करा है जी under freedoms given for under article 19, that is the reasonable restrictions can be placed if to preserve public order, to maintain friendly relations with foreign states, and to avoid incitement of offences. Okay, तीनटा restriction नुआ add करा गला first constitution amendment act रे under article 19, and it validated the nationalization of trade or business despite the right to trade. Okay, एई जिनसटा तमरो article 19 clause 6 रे अछि. Okay, जे तमरो कोनोसी right to engage in any trade or profession or livelihood, but nationalization of banks nationalization of trade and business can be done under Article 19 plus 6 এই জিনিসটা ବି ତମର add କରାଗଲା 7th Constitution Amendment Act okay ତମେ এটা ଜାଣିଛ 7th Constitution Amendment Act was made to implement the recommendations of State Reorganization Commission okay State Reorganization Commission जोटा कि 1953 रे ହେଇଥିଲା it is also called the Fazal Ali Commission okay Fazal Ali Commission, SRC 1953. So, to implement the recommendations of this commission, this amendment was passed. It extended the High Court jurisdiction to Union territories, additional and acting judges in High Courts, introduced common High Courts for 2 or more states, okay, abolished this class ABCD states, reorganization of 14 states and 6 Union territories, okay. Okay, Article 153, it provides for one governor can be assigned for 2 or more states simultaneously. Okay, that is Article 153 was amended in 7th Constitutional Amendment Act. Then comes the 9th, provided for territorial adjustment after Indo-Pak Agreement, also called the Nehru-Noon Agreement. Okay. Nehru-Noon Agreement after Indo-Pak Agreement. Okay, Berubar Union, West Bengal was ceded to Pakistan. 14th Constitutional Amendment, okay, एवढा इतने दरकार नहीं हम मन रखी परियो 14 CA created Legislature and Council of Ministers for Union Territories, okay, 14 CA रे एटा important मन रखी पारो, okay, 16th एटा दरकार नहीं expanded government authority restrict free speech, okay, okay, एटा 16th भी दरकार नहीं 24th very important as I have already said it affirmed that Parliament can has power to amend any part of Constitution including fundamental rights mandatory for President to give assent to Constitution amendment bills. Okay, 24th CA important. 25th, 25th also important. Curbed right to property. Okay, right to property curb करागला. Protected laws under Article 39B and 39C. DPSP. DPSP रे जो law गुड़ा जदी implement करिवा को state जदी initiative नला, then the fundamental rights under Article 14, 19 and 31 they take back seat. Okay, here a case DPSP comes to the forefront. Okay, that is 25th CAA. 26th, okay, 26th abolition of privy purses and privileges for princely states. Okay, that मन रखियो may be बेले बेले को exam रे पचार दिए 26th Constitutional Amendment Acts deals with abolition of privy purses. 35th, okay, 35th is important no, but okay, ended protectorate status of Sikkim. Sikkim made an associate state of India. Okay, Sikkim गोटे protectorate थिला, तापरे Sikkim को गोटे India रा associate state करागला under 35th Constitution Amendment Act. Okay, and Sikkim full state ହେଇଗଲା under 1975. Okay, 1975 रे Sikkim became a full fledged state. So ଏଇଟା ଗୋଟେ ଜିନିଷ ମନେ ରଖିବ at a 10th schedule, that is 10th schedule ରେ କଣ ଥିଲା about terms and conditions of association of Sikkim with the Union of India. Okay, तो तमें हमें जानी जा 10th schedule is 52nd Amendment Act of 1985 that हमें जानी जो anti-defection law that is associated with 10th schedule, but please note that 35th CAA रे तमरो 10th schedule introduce कराइतला for to make Sikkim an associate state with India, Union of India. तापरे 36th CAA रे तमरो सिक्किम जतले फुल प्ले स्टेट हेगला इंडिया रे 10th शेड्यूल को ओमिट कर दिया गला. ओके, एटा गोटे जस्ट गोटे फैक्ट मन रखिथिबो. 39 CAA emergency time रे एटा कराइता introduced during emergency placed election of president, vice president, PM, speaker of Lok Sabha beyond the judicial review, beyond court scrutiny. Okay, 42nd CAA mini constitution preamble socialist secular और integrity word add करा गला. Fundamental duties were introduced under part 4A. Okay, and new DPSP add करा गला, that is healthy development of children article 39, equal justice and free legal aid article 39A. Okay, and worker participation in industries article 43A, protection of environment, forest and wildlife under article 48A. Okay, DPSPs were given primacy over fundamental rights. Okay, so DPSP रा provision होची, it is DPSPs are command to state to do something. Fundamental rights they limit the state. Okay, एबे DPS एबे ए 42nd Amendment Act रे कहला जे state चाहिए जहाँ भी कर परिवो, state रा कोनोसी fundamental right भी ताको limit कर परिवो नहीं. Okay, DPSPs were given primacy over fundamental rights. Elections, delimitation of constituencies were postponed till 2001 census. এই জিনিসটা আপনি নোট করিব. Delimitation of constituencies postponed till 2001 census. Parliament was bound by the cabinet advice on restricted amendment powers. It can amend anything. Judiciary, Supreme Court review was curtailed. Amendments and the parliamentary constitutional amendments are immune to be challenged by the judiciary. Federalism, पांचटा subject were moved to concurrent list, from state list to concurrent list. That 8 inch मन रखियो, this is important. 5 subjects. What are those 5 subjects? that is education, forest, weight and measure, protection of wild animals and birds, administration of justice. Okay. Administration of justice এই ଜିନିଷଟା ଗୋଟେ ଦେଖିବ ତମର protection of environment, forest and wildlife under article 49A and ଏଥିରେ forest ଉପରେ deal କରାଯାଇଛି ତମର again state list to concurrent list ରେ move କରାଗଲା forest and protection of wild animals and birds. Okay. ତମର environment ରେ ପଡିଥିବ ତମର wildlife protection act 1972. Okay. Wildlife Protection Act 1972. This act was also amended under the 42nd Constitutional Amendment Act that transferred wildlife from state to concurrent list. Okay. WPA 1972P amend କରାଯାଇଥିଲା 42nd CAA under ରେ ଏ ଜିନିଷଟା environment ରେ ପଡିଥିବ ମନେ ରଖିବ ଏ ଜିନିଷଟା emergency allowed localized emergency president rule extended to 1 year. Okay. ବର୍ଷ ଥରେ declare ହେଇଗଲା ମାନେ ଗୋଟେ ବର୍ଷ ଯାଏ ଚାଲିବ emergency president rule. 43rd CAA deals with high court mostly एते important नहीं restored the powers of high courts. Okay. जोटा 42nd रे curtail कराइतला ताको restore कर दिया गला. High court is principal civil courts of original jurisdiction in states or UT. States or UTs रे high court माने original jurisdiction अछि. High court regained the power to strike down central laws as unconstitutional. Okay. 44th again this is also important. Emergency रे तमरो article 352 national emergency रे तमरो it replaced internal disturbance with armed rebellion under national emergency article 352. President can declare emergency only with written cabinet advice. Okay. Right of property को delete करेगा from fundamental rights. It made it a legal right. So ये जो 44th CA रे हम जिम देखले article 31 जोटा थिला article 31 was repealed under the 44th Constitution Amendment Act and this right to property. Article 31 dealt with right to property. Right to property became a legal right under article 300A. Okay, under article 300A. So 44th Amendment Act repealed article 31. Okay. So it also ensured that article 20 and 21 cannot be suspended even during emergency. 20 तमे जानछो this provides protection with respect to conviction for offences and 21 deals with right to life and liberty. All right. Now comes the very important 52nd CAA 1985. ये जिनसटा नोट करो एटा I think सब वर्ष OPSC रे प्रीलिम रे पचारुची UPSC रे भी एटा बहुत गोटे मेजर थीम जो ऊपर UPSC कंसंट्रेट करे that is the anti defection law. 52nd CAA रे anti defection law introduce करागला where MPs and MLAs are disqualified for defection added 10th schedule. Okay, हमें already देखिचे तमरो सिक्किम रे 10th schedule ऐड कराइतला सिक्किम पई. Okay, under 35th and 35th amendment act रे तमरो 10th schedule ऐड कराइतला 36th रे रिमूव कर दिया गला. Similarly 52nd amendment act रे तमरो 1985 introduced the anti defection law. Okay, तो anti defection law ऊपर टिके देखि दवा भलसे last page रे अछि anti defection law background. It was enacted via 52nd amendment act of 1985 prevents political defection and ensures party discipline. Okay, articles को amend करा गला. Vacation of seats of parliament 101, 102 disqualification of for parliament, 190 vacation of seats for state. Again say 101 रे तमरे plus 89 कर दियो तमरो 190 आसीबो. parliament जोटा state हेइ जीवो. disqualification for parliament, disqualification for state legislature 102 रे तमे 89 ऐड कर दियो तमरो 191 आसीबो. Addition करागला 52nd 10th schedule ground for disqualification due to defection. तो law रे कोन सब provision थिला disqualification criteria. Political party members will be disqualified if they voluntarily resign from their party or they vote or abstain against the party whip. Okay, they vote or abstain against the party whip unless their abstention or unless their vote of their negative vote is condoned by the party within 15 days. এই জিনিসটা তোমার কনস্টিটিউশন রে মেনশন ଅଛି 10 शेड्यूल रे जदि पार्टी 15 दिन भितर तांका डिसीजन को एक्सेप्ट कला ताहले सेमाने को डिस्क्वालिफाई करा जीवनी. ओके, इंडिपेंडेंट मेंबर्स कैन बी डिस्क्वालिफाइड इफ दे जॉइन ए पॉलिटिकल पार्टी आफ्टर इलेक्शन. नॉमिनेटेड मेंबर्स कैन बी डिस्क्वालिफाइड इफ दे जॉइन ए पॉलिटिकल पार्टी आफ्टर 6 months ऑफ नॉमिनेशन. बिफोर 6 months ऑफ नॉमिनेशन कले सेमाने डिस्क्वालिफाई हेबेनी. नॉमिनेटेड मेंबर्स जदि आफ्टर 6 months कले दे विल बी डिस्क्वालिफाइड. एक्सेप्शन provide karagala merger there is no disqualification if 2/3 of member agree to a merger. Okay, एटा 91st constitutional amendment act रे भी जिनसटा को ऐड करा है जी एटा हमें देखिबा या पर presiding officer. Okay, एटा he or she may resign the party membership after election as speaker or chairman. Okay, जदि presiding officer speaker की chairman हला पर ता party छाडी दोउची ताहले they will not be disqualified under 10th schedule because it like voluntary resign kala tamar member disqualify ହେଇଯିବ, but this case is not applicable for the speaker. Okay, not applicable for the speaker or chairperson. Okay, adjudicate किए करिवो प्रिसाइडिंग ऑफिसर, जो डिस्क्वालिफिकेशन रो केस को किए adjudicate करिवो दैट इज द लोकसभा स्पीकर और राज्यसभा चेयरमैन. डिसीजन नेबा पे किछि टाइम लिमिट नाही, एटा गोटे क्रिटिसिज्म ऑफ 10th शेड्यूल, किछि टाइम लिमिट नाही. एंड सुप्रीम कोर्ट इन किहोटो हुलुहान केस 1993, सुप्रीम कोर्ट रो डिसीजन सब्जेक्ट टू ए जो स्पीकर रो डिसीजन इज सब्जेक्ट टू जुडिशियल रिव्यू. ओके, स्पीकर जो ग्राउंड रे डिस्क्वालिफाई करिवो मेंबर्स मानको दैट कैन बी सब्जेक्ट टू जुडिशियल रिव्यू. ओके, now comes the rule making power. Okay, disqualification by rule making power kahar achi, presiding officer again frames the rule for 10th schedule that is approved by house within 30 days. Procedure is procedure for bringing 10th schedule into action is first complaint file kara jibo, accused member is given a chance to respond, then decision issued by the presiding officer. Whip of the party, they ensure party attendance and discipline. Whip को defy kale tamar anti defection lagi jibo. Okay, 91st Constitutional Amendment Act 2003 रे तमरा एंटी डिफेक्शन लॉ को आउथरे स्ट्रेंथन करा हितला. ओके, ए दिनसटा तमरा प्रीवियस ईयर ओपीएससी रे पचारि छि. ए दिनसटा 91st सीए आर्टिकल कोन सब चेंजेस करा गला आर्टिकल 75 रे यूनियन 91st Constitutional Amendment Act रे काउंसिल ऑफ मिनिस्टर रो साइज शुड बी लेस देन 50% ऑफ लोक सभा स्ट्रेंथ. 15% ऑफ लोक सभा स्ट्रेंथ. ओके, प्लीज नोट 15% of Lok Sabha strength. तमरो again article 75 तार state counterpart is article plus 89 कर दियो, तमर state आसीबो. State council of ministers should be less than 15% of assembly strength. Okay, minimum 12 हे करिवो, दिल्ली रे 10%. ओके, ए दिन सवडा तमरो जेंति आगरो जेंति काउंसिल ऑफ मिनिस्टर रो स्ट्रेंथ बहुत बहुत होतला. ओके, ताको लिमिट करिया पई 91st सीए इंट्रोड्यूस करा हितला. 75 रे disqualified members cannot become ministers until re-elected. Okay, 75 रे disqualified members cannot be ministers until re-elected. सेमती 164 रे एथरे 89 लागिवनी, तमरो प्लस 89 जोटा लागिवनी. आर्टिकल 1 disqualified members ineligible as ministers in state legislative assemblies. आर्टिकल 361 बी. ओके, disqualified members जो माने cannot hold remunerative political posts. ओके, समारे हाउस रो डिस्क्वालिफाई हेले तापर समारे remunerative भलो भलो पॉलिटिकल पोस्ट भी होल्ड करि परिबे नाही. एटा स्पेसिफाई करा हैछि 91st अमेंडमेंट रे. ओके, 10th शेड्यूल डिलीटेड द एक्सेप्शन फॉर 1/3 स्प्लिट. तो आगुरु गोटे थिला जे तमरो जदी 1/3 स्प्लिट 1/3 मेंबर जदी स्प्लिट करिके अलगा पार्टी करछंदी देन दैट इज अलाउड. बट 91st अमेंडमेंट रे ए दिनसटा एई प्रोविजन टा को डिलीट कर दिया गला. एबे आसिला 2/3 मर्जर रूल ही रहिला. एबे 2/3 मर्जर रूल कोन, जदी जदि तमरा पार्टी मेंबर्स माने जदि 2/3 मेंबर्स ऑफ ए पार्टी दे डिसाइड कि they decide to merge with some other party. Okay, then that is then they will not be disqualified according to the 10th schedule. Okay, एई दिनसटा 91st Constitutional Amendment Act रे एई दिनस गुडा सब स्पेसिफाई करा हेइथिला. ओके, तमरो ओपीएससी 2023 क्वेश्चन पचारथिला एंटी डिफेक्शन लॉ ऊपर. एंटी डिफेक्शन लॉ फाउंड प्लेस इन द कॉन्स्टिट्यूशन बाय द 52nd Constitutional Amendment. That is true. 10th schedule was inserted in constitution in the year 1989. এটা 1985 হবো, ଆମେ ଦେଖିଲେ এটা. ତ second statement ଟା ଭୁଲ ଅଛି. Okay, anti defection law was enforced in the year 2002. Okay, 2002 ଦେଇଛି, ଆମେ କଣ ଦେଖିଲେ 2003 91st CAA 2003. Okay, 91st CAA 2003. এই ଜିନିଷଟା ତମର ଓପିଏସସି ଠିକ କହିଛି, ବଟ୍ ଇଟ୍ ଇଜ ଏ ପ୍ରିଣ୍ଟିଂ ମିଷ୍ଟେକ୍. ଏଟା 2 ନୁହଁ, ଏଟା 3 ହବ. ବିକଜ ଏଟା ମୁଁ ଅଲରେଡି ଚେକ୍ କରିଛି 91st CAA ଏଟା 2000 ଇଟ୍ ଗଟ୍ 2003 ରେ ପାସ୍ କରାଗଲା. ପ୍ରେସିଡେଣ୍ଟ ଆସେଣ୍ଟ ପାଇଗଲା ଏଟା 2004 ରେ. ସୋ ଏଟା 2002 ହେବାର କିଛି କ୍ୱେଶ୍ଚିନ୍ ହିଁ ନାହିଁ. ଓକେ, ଏଟା 2003 ହବା କଥା. If any member who is independently elected joins any political party, he is not disqualified. এটা ভুল ଅଛି. ओके, तो पचारछि which of the following is correct. तो आंसर 1 and 3 एटा ठीक अछि, 3 टा ठीक अछि, 2 और 4 भूल अछि. आंसर 1 and 3 हबो, बट 3 रे अगेन प्रिंटिंग मिस्टेक अछि. ओके, तो पचारछि if any member independently elected is joined political party is not disqualified. That is not true. जदि इंडिपेंडेंटली इलेक्ट हेइ जंती, जदि पॉलिटिकल पार्टी जॉइन कले से डिस्क्वालिफाइड हेबे. ओके, तो Supreme Court cases regarding the anti-defection law. Eta tomar mains re bhi tomar eguda सब use कर परिबो case studies गुड़ा. Quixote Holihan versus Jachilo case. Judicial review of speaker decision is upheld. Ravi S. Naik versus Union of India defined voluntarily giving up membership. Okay. तो रवि एस नाइक केस रे कौन इतला जदि एमपी की एमएलए they do not need to formally resign from the party if disqualified under 10 schedule. Okay. जदि 10 schedule disqualified ହେଇଗଲେ ସେମାନେ ପାର୍ଲାମେଣ୍ଟରୁ ସେମାନଙ୍କୁ ଯିବାକୁ ପଡିବ ବଟ୍ ଏମିତି ନୁହଁ ଯେ ସେମାନେ ଭଲଣ୍ଟାରଲି ପାର୍ଟି ମେମ୍ବରସିପ ବି ଗିଭ୍ ଅପ୍ କରିବାକୁ ପଡିବ ସେମିତି କିଛି ମାନେ ନାହିଁ ଓକେ then G Vishwanath versus Speaker of Tamil Nadu expelled members become unattached members okay expelled members become unattached members of the house okay but they can also stay as party member they cannot be members of the parliament but they can be party members Srimant Balasaheb Patil versus Karnataka whip is not binding during trust votes like no confidence motion okay so again it recommended that a specific ଏଇଥିରେ recommend କରା ଗୋଟେ specialized tribunal କରାଯାଉ for to decide the disqualification cases not speaker should not decide but a specialized tribunal should decide okay then Keisam Meghachandra Singh versus Manipur it suggested again independent adjudicatory mechanism it suggested that constitution the 10th schedule ପାଇଁ ଏଇ ଯୋଉ cases ଯାହା ବି ସବୁ ଆସୁଛି ତା ପାଇଁ ଗୋଟେ independent adjudication process ଗୋଟେ ତିଆରି ହଉ same thing ଯୋଉଟା କି ଗୋଟେ tribunal ଭଳିଆ କିଛି କରାଯାଉ same thing okay so these are the Supreme Court cases regarding the 10th schedule so we'll now come back to the topic okay କରୁଥିଲେ ଆମେ 52nd okay 52nd CA 1985 91st CA 2003 not 2002 not 2002 as given in OPSC question okay further strengthen the anti-defection law remove the split expression 2/3 merger ही रहिला 1/3 split expression को remove कर दिया गला cap the size of ministries as we have already seen 61st CAA 1989 this is important very important reduce the voting age from 21 to 18 years Lok Sabha and state assembly elections okay for 21 to 18 69 CAA also important granted special status to Delhi became NCT created 70-member legislative assembly and several member council of ministers for Delhi. Okay. 69 CA, এটা তোমার নিউজ রে থাকে due to the tussle between Delhi and central government. 73rd CA, okay, এটা তো তুমি জানছো 73rd and 74th, এটা তোমার পঞ্চায়েত municipalities ପଞ୍ଚାୟତର 29ଟା ଫଙ୍କସନ ମ୍ୟୁନିସିପାଲିଟିର 18ଟା ଫଙ୍କସନ 84th CA 2001 it extended the freeze and seat readjustment in Lok Sabha and state assemblies up to 2026 okay ତମେ ଏଇଟା ଜିନିଷ ଦେଖିଛ ଅଲରେଡି ମୁଁ କହିଛି ତମକୁ 42nd constitutional amendment act ରେ ତମର delimitation of constituencies till 2001 census ଯାଏ postpone କରି ଦିଆଗଲା 42nd constitutional amendment act ରେ ତମେ ଏଠି 42nd into 2 କରିଦିଅ that is 84th constitutional amendment act 2001 रे ସେଇ freeze ଟାକୁ extend कर दिया गला till 2026 okay 84th to encourage population control measures okay 86th constitutional amendment act again very important made elementary education from 6 to 14 years as a fundamental right under article 21A in modified article 45 of DPSP that early childhood care and education for children under 6 years okay ଏଇଟା ହଉଛି DPSP ରେ introduce କରାଗଲା ଆଗରୁ କଣ ହେଇଥିଲା ଏଇ ଯୋଉ 6 ରୁ 14 ବର୍ଷରେ 14 ବର୍ଷ ପିଲାଙ୍କୁ ଏଜୁକେସନ ଦିଆଯାଇଥିବ ଏଇଟା DPSP ରେ ଥିଲା ଫଣ୍ଡାମେଣ୍ଟାଲ ରାଇଟ୍ ରେ ଏଜୁକେସନ କିଛି ପ୍ରୋଭିଜନ ନଥିଲା ଏବେ କଣ କରାଗଲା ଏଇ ପ୍ରୋଭିଜନ କୁ ଏଠିକି ଫଣ୍ଡାମେଣ୍ଟାଲ ରାଇଟ୍ କୁ ନେଇ ଦିଆଗଲା ଆଉ DPSP ରେ ତମର early childhood care and education କୁ introduce କରାଗଲା okay 6 to 14 years as fundamental right under article 21A added a new fundamental duty under article 51A that is duty of parents to provide education 86th CA 89th CA also important it okay it split the National Commission for SC National Commission of ST under article 338 and 338A respectively then 97 through 106 97th CA granted constitutional status and protection to cooperative societies okay please note cooperative societies made right to form cooperative societies a fundamental right under article 19 okay right to form cooperative societies 97th CA inserted a new DPSP for promotion of cooperative societies under Article 43B, added Part 9B, the cooperative societies. Okay, it is important. 97, 99th CAA, that is, it established the NJSC, but 2015 the NJSC was declared as unconstitutional and the collegium system was reintroduced. Okay. Then comes the 100 CAA 2015, implemented the land boundary agreement between India and Bangladesh 2015. Okay. Then comes the 101st CAA. तमरो 101st to 106th CAA पर्यंत तमरो एटा मने रखियो because these are recent amendments and एगुडा तमरो एग्जाम रे पचार दबो. Okay. तमरो Constitutional Amendment Act सहित तमरो केते नंबर बिल सेटा भी मने रखो. 101st CAA is the 122nd Constitutional Amendment Bill. Okay, because constitution amendment bill टा तापरे पास ହେଲା ପରେ से constitution amendment act हबो. Okay, 102nd ସବୁ bill गोटा act हुएनी, constitutional amendment act हुएनी. Okay, so 101st constitutional amendment deals with the GST. Okay, that was introduced with the that came into effect with the 102nd constitution amendment bill. Okay, 102 constitutional amendment act, this was the 123rd Constitutional Amendment Bill. Okay, granted constitutional status to National Commission for Backward Classes. Inserted Article 338B. 338B re NCBC became a constitutional body. Then comes the 103rd Constitutional Amendment Act with the 124th Constitutional Amendment Bill. Introduced 10% reservation for EWS and added Article 15 and 16. Exempted minority-run institutions upheld by Supreme Court in 3:2 majority. Okay. 104th CAA extended reservation of seats for SC/ST in Lok Sabha and State Assemblies till 2030. 104th CAA under 126th Constitutional Amendment Bill. Okay, please note the कि 124th पर 126th है गला. तमरा 125th Constitutional Amendment Bill has not been passed till now. Okay, यहाँ पर हमें कोई भी यहाँ पर. So 104th enabled special representation of okay, enabled no ended special representation of Anglo-Indians in Lok Sabha and state legislative assemblies. It ended the special representation provision. 105th with the 127th constitutional amendment bill empowered states to prepare and maintain their own list of SCBC because हमारा 102 नंबर constitution amendment act रे NCBC को constitutional status दिया गया. तापरे कोर्ट कहला जे स्टेट मानकर जहाँ भी SCBC अछंती सेटा NCBC डिसाइड करिवो. ओके, तो सेतमे पार्लियामेंट फॉरवर्ड कला 105th CAA empowered states to prepare and maintain their own lists without consulting the NCBC. Then comes the 106th Constitutional Amendment Act under 128th Constitutional Amendment Bill. ओके, तमरो ओपीएससी रे थरे पचार देथला को बिल तमो एक्ट पचार नथला. एक्ट पचार थला हम पे सुविधा हम कहि परिबो हां ए एक्ट रे ए हितला, बट बिल पचार देले कंफ्यूजन रुहे. सो बिल ऊपर भी ध्यान देबो, स्पेशली आफ्टर दी 100 फास्ट रो ही तम ध्यान दियो, बाकी पुराना बेसी इंपोर्टेंट नहीं. ओके, तो 106th रे reserved 1/3 seats for women in Lok Sabha, state legislative assemblies and legislative council of NCT for Delhi includes seat reserved for SC and STs. Okay, for women reservation. This provision will come into effect after the next census. Okay. 125th Constitution Amendment Bill. तमर क्षेत्र कौन हितला? It proposed to increase the powers of the tribal autonomous councils of 6 scheduled areas. Okay, the financial, executive and administration powers of tribal autonomous councils of 6 scheduled areas of Assam, Meghalaya, Mizoram and Tripura. But एबे एटा currently parliament रे stall है जी. एटा किसी movement नहीं. तापरे because of the disagreement regarding distribution of powers. Okay, तो एटा जदला act हबो, एटा गोटे ए बिल टा जदला act हबो सेतबेले या परे को constitutional amendment act होजी सेटा परे देखा हबो. Okay, so this is all about the constitution amendments. Okay, next comes the एबे हमें लास्ट देखि दबा तमरो DPSP ऊपर evolution of basic structure doctrine. ओ सॉरी, DPSP कहूची basic structure. Okay, basic structure doctrine. तो ठीक अछि, तो देखिबा की आइडिया. It basic structure deals with the core values forming the bedrock of constitution. Okay, it is not defined by the constitution or not explicitly by the Supreme Court. Okay, just a second. Basic structure not defined in constitution or by the Supreme Court. It evolved through judicial interpretation. Okay, Parliament cannot amend the basic structure under Article 368. I have already देखिले evolution of cases. So it is not defined in constitution by Supreme Court. Evolved through judicial interpretation. Protects the constitution, the core values and vision of the founding fathers. Present position होची Parliament can amend any part of the constitution, including fundamental rights, but not the basic structure, as affirmed in the Minerva Mills case of 1980. Okay, तो basic structure तमे गोटे कॉन्सेप्ट कहि दउची आई थिंक दिस इज इंपोर्टेंट दैट्स व्हाई मु कहूची एई कॉन्सेप्टटा तमरो ड्यू प्रोसेस ऑफ लॉ रे भी बुझिया पई तमरो हेल्पफुल हबो दैट इज द प्रिंसिपल ऑफ नेचुरल जस्टिस ओके प्रिंसिपल ऑफ नेचुरल जस्टिस तो नेचुरल जस्टिस तो जस्टिस माने न्याय देवा ओके तो जस्टिस रा सोर्स कोन ओके सोर्स ऑफ जस्टिस इज रीजन justice can okay justice is enacted through law okay enacted through law a justice ର source କଣ that is human reason okay human reasoning କରିକି ହିଁ ଗୋଟେ law ତିଆରି କରିଛି law implement ହେଲେ justice ଆସିବ ତ ଏଟା କରିବା ପାଇଁ ଗୋଟେ ତମର human reason is the source of law and is this law will give us justice okay ଏଟାକୁ first ह्यूमन रिजन रु तमर लॉ आसीबो ए लॉ रु तमर जस्टिस आसीबो ओके तो केतेक जगह रे तो केतेक कॉन्स्टिट्यूशन रे एक्सेप्ट करा जाय जे लॉ इज इवॉल्विंग ए जो सेंस ऑफ जस्टिस के लॉ एटा विथ टाइम चेंज हुए ओके किंतु गोटे गोटे जगह रे तमर ए इवोल्यूशन टा को रेस्ट्रिक्ट कर दिया जाय ओके तो सेठु सब अकॉर्डिंग टू द फ्लेक्सिबिलिटी और रिजिडिटी देयर आर स्कूल्स ऑफ लॉ ओके गोटे स्कूल अछि स्कूल ऑफ नेचुरल लॉ okay school of natural law this is flexible out hochi this is rigid that is school of positive law माने state made law or religious law हो okay religious law हो so एई law माने these are rigid समाने गोटे टाइम रे ओके तांकर भी सोर्स होची ह्यूमन रीजन किए किए तांको से लॉ तैयारी करथले कि ह्यूमन ही करथले बट विथ टाइम दे बिकेम रिजिड so they are no, now they cannot be changed okay positive law means state made law that is तो स्टेट जदि गोटे लॉ कर देछि ताको आ केही चैलेंज कर परिबे नहीं करि परिबे नहीं एगुड़ा सब हुए तमर डिक्टेटोरियल रिजिम्स रे ओके रिजिड लॉज रिलीजियस लॉज रिलीजन जदि किछि कहि देछि लॉ कर देछि ताल ताको केही चैलेंज कर परिबे नहीं जेमति तमर सऊदी अरेबिया हो ओके that is the school of religious law school of natural law what is school of natural law it derives from the school of natural justice okay it derives from the principle of natural justice okay natural justice कौन जे समय सहित चेंज हेबाको हेले हमको समय सहित चेंज हेबाको पड़े मींस समय सहित चेंज हुए हमको अकॉर्डिंगली एडजस्ट करियाको पड़े समय सहित ओके ताहेले ही हमें इवॉल्व कर परिबा गोटे रिजिड पैटर्न रे रही गले हमें इवॉल्व करि परिबा नहीं so natural law respects that theory that thing why it is called natural law because it derives itself from human reason जोटी अछि human reason will decide whether the law will continue or change with time okay तो ସେଇଠୁ प्रिंसिपल ऑफ नेचुरल जस्टिस ଆଉ प्रिंसिपल ऑफ नेचुरल लॉ रू ही तमरा आसीची द कांसेप्ट ऑफ बेसिक स्ट्रक्चर डॉक्ट्रिन एई जिनसटा तमरा ड्यू प्रोसेस ऑफ लॉ रे भी एप्लीकेबल हबो दिस प्रिंसिपल ऑफ नेचुरल जस्टिस और प्रिंसिपल ऑफ नेचुरल लॉ एटा तम ड्यू प्रोसेस ऑफ लॉ संगे रे भी रिलेटेड अछि जेटा हमें परे देखिबा ओके सो बेसिक स्ट्रक्चर डॉक्ट्रिन बिलोंग्स टू द स्कूल ऑफ नेचुरल लॉ okay we can also say that school of natural law eta with time sabu bele according to the demand of the situation or circumstance it is organic it is evolving it changes with time according to the situation okay so evolution okay again mu jemti कहिथले first part रे amendment of constitution रे evolution landmark cases शंकर प्रसाद केस 1951 रे तमर first constitution amendment act that curtailed the right to property एटा को अपहेल्ड करा गला Parliament एथरे सुप्रीम कोर्ट कहला जे Parliament can amend fundamental rights under Article 368 and these amendments are not to be counted as law under Article 13 clause 3 okay we have seen this then comes the Sajjan Singh versus State of Rajasthan 1965 same thing Parliament can amend fundamental rights but it upheld the okay 17th CAA it was related to the land reforms okay and it reaffirmed the Parliament amending power as given in the previous case that Parliament amend kar paribo but there was a dissent judgment okay this dissent hinted that fundamental rights should not be changed okay then comes the Goloknath case re Supreme Court कहला Parliament cannot amend fundamental rights these fundamental rights are transcendental and immutable you cannot amend fundamental rights and these amendments will be counted as law under Article 13 clause 3 and they will be subjected to judicial review then comes the 24th CAA restored the parliament's power to amend any part of constitution, made presidential assent to CAA, Constitution Amendment Acts, mandatory. Okay. Restored Parliament's power to amend any part of the Constitution, including fundamental rights. Kesavananda Bharati case upheld the 24 CAA, but Parliament can amend anything, but subject to basic structure of Constitution. So Parliament cannot alter or destroy the basic structure. Okay. Then comes the Indira Gandhi case versus Indira Gandhi versus Raj Narayan case. It struck down the 39th Constitutional Amendment Act, where the election disputes of Prime Minister was kept outside judicial review. It said that judicial review is a part of basic structure and cannot be curtailed by the Parliament. 42nd CAA, Parliament claimed unlimited powers and barred judicial review of amendments, but it was struck down in the Minerva Mills case. Minerva Mills case versus Union of India, आर्टिकल जो 42nd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट रो प्रोविजन गुडा को स्टॉप डाउन कर दिया गला सो एथरे कोआ गला जे तमरो 42nd अमेंडमेंट एक्ट रो जो बारिंग ऑफ जुडिशियल रिव्यू ए जिंस गुडा को अमेंडमेंट कर ए जिंस गुडा को तमरो स्टॉप डाउन कर दिया गला and Supreme Court said that the constitution runs on the balance between fundamental right and UPSP, which are part of basic structure. Vaman Rao versus Union of India case re BSD basic structure doctrine applies prospectively. Amendments after 24th April 1973, this is the date of Kesavananda Bharati case, are subject to basic structure doctrine. Indira Sahni versus Union of India case 1992 upheld the 27% OBC reservation and capped the total reservation at 50%. Equality is a part of basic structure. Okay. तो टोटल रिजर्वेशन तुम 50% क्रॉस कर परिबनी एटा इंदिरा साहनी केस रे कहैतिला ओके कि होटो होलुहान वर्सेस जाचिलु upheld 10th schedule anti-defection law but allowed judicial review again. Free elections and democracy are part of basic structure. SR Bommai versus Union of India, secularism, federalism and democracy are part of basic structure. President rule is subjected to president rule ऊपर जो document को rely करके president rule लगा है those documents are subjected to those decisions of president को decision को material को refer करा है कि president rule लगा है those materials are also subjected to those materials and decision of the president is subjected to judicial review. IR Koira versus State of Tamil Nadu, 9 scheduled laws are open to judicial review if they violate basic structure doctrine. Okay, IR Koira 2007 case. KS Puttaswamy case, right to privacy is as a fundamental right, it is also part of basic structure. So देखो बेसिक स्ट्रक्चर तमे इवोल्यूशन देखिलो तो इवोल्यूशन केते बाटे हेची सबु कॉन्स्टिट्यूशन अमेंडमेंट एक्ट रे बेसिक स्ट्रक्चर को इवॉल्व करा हेची इट इज इवॉल्विंग according to situation. Okay, it is organic जिन गोटा organism grow करे it is evolving, it is organic, it is adjust according to the demand of time. Okay, it is not static, so that's why it is counted as a component of principle of natural justice or principle of natural law that allows for changing according to circumstances. It is not rigid, just like as we have said in the school. This law is not rigid like the positive law or religious laws. Okay, it is natural law that is evolving. Okay, so components of basic structure, elements of basic structure, that is supremacy of constitution, rule of law, elections, free and fair elections, parliamentary system, federal regime, secular regime. Okay, एड़ा सब तमे जानि छ एड़ा जस्ट किछि रीडिंग मारिया कथा खाली. आर्टिकल 332 तमरो Article 32 तमरो writs of Supreme Court. Article 136 तमरो Supreme Court can grant special leave to appeal against any judgment or order against the decision of a lower court or tribunal. Article 141 तमरो it sets a judicial precedent that a law declared by Supreme Court is binding on all courts and authorities within the territory of India. Article 142 this is a provision of complete justice. Supreme Court can pass any order or decree that will serve complete justice. Power of High Courts under Article 226, that is writs, and 227 High Courts have superintendence power over all other courts. Okay, so so these are part of basic structure. Principles of equality, dignity, freedom and dignity of individual, unity and integrity of nation, separation of powers, harmony between fundamental right and DPSP, Minerva Mills case, welfare state. Okay, significance, it protects the fundamental rights from arbitrary amendments. Okay, so arbitrary amendments preserves the constitutional ideas and vision of the founding fathers. Supremacy of constitution रहिबो over a temporary parliamentary majority. Okay, parliament जदि majority राज जाइछि किछ समय पय ताल चाइले से किछ ना जहा नै ता कर परियो constitution सहित से दिनसटा अलाउ हबनी. Reinforces democracy, secularism, federalism, strengthens separation of powers, judicial independence. Constitution keeps constitution a dynamic, living document and a progressive document. That is school of natural law. or school of natural law, principle of natural justice. Encourages judicial activism as a check on legislature or executive. Criticism कौन? Separation of power नहीं. Judiciary limits the parliament's amending power. Vagueness. There is no final definition of basic structure. There is ambiguity. Okay. So it depends on the human region. Human region can work in various ways. ତା ଦେହରେ କିଛି ସେ କେମିତି କାମ କରିବ ସେଥିରେ କିଛି fixed pattern ନାହିଁ. Okay. ହ୍ୟୁମାନ ରିଜିନ୍ ଯୋଉଟା କି ଜଜ୍ ମାନଙ୍କ ରିଜିନ୍ ସେଇଥିରୁ ହିଁ ତମର ବେସିକ ଷ୍ଟ୍ରକ୍ଚର ଡିସାଇଡ୍ କରାହଉଛି ଦ୍ୟାଟ୍ ରିଜିନ୍ କ୍ୟାନ୍ ବି ଏନିଥିଙ୍ଗ ତାର କିଛି ଆମ୍ବିଗୁଟି ନାହିଁ that can be vague. Okay, it cannot predict it. Judiciary is the third chamber of parliament. Okay, that undermines democracy. Judicial overreach like NJC Act was struck down, citing basic structure doctrine of judicial independence. Balance of power is tilted towards judiciary. Parliament sovereignty is reduced. Okay, देखो judiciary ताकू जोटा की इच्छा लागियो ताकू जदि लागियो ए जिंसटा रिजनेबल से अकॉर्डिंग टू नेचुरल लॉ दिस इज वैलिड अकॉर्डिंग टू नेचुरल लॉ कहि कि ताकू पास करे दबो. सो गोटे जुडिशियल सुप्रीमेसी आसी जाउछ. पार्लियामेंट रो सोवरेनिटी को रिड्यूस करा होछ. ओके, so this is all about the basic structure.